Anderson, who joined the DeVos Center in this year, 2012, is also the editor of Public Discourse, the online journal of the Witherspoon Institute in Princeton, New Jersey, which I read almost daily, so I'm delighted to meet you in person. His previous positions include assistant editor of the journal First Things. He was a journalism fellow at the Phillips Foundation, executive director of the Witherspoon Institute, where he was research assistant to Professor Robert George and Jean Bethke Elshtain. So, without further ado, how about we proceed to our panel discussion. Let's talk about the nature of these web-based platforms and the extent to which, if any, the First Amendment applies to them. In Craig's paper, True Liberty in the New Media Age, Craig pointed out that in 2007, when the FCC considered so-called net neutrality regulation, the Commission presumed that the First Amendment does not apply to restrain the ability of these new media companies to regulate content or viewpoint of private actors on the Internet. Now, Commissioner McDowell, you were on the FCC at that time. What do you think about that presumption that the FCC made about the applicability of the First Amendment's restraints on new media companies that are private?
First of all, is this on? There we go. First of all, thank you very much for having me here today. This is an excellent panel, and it's a very important issue, and I'm looking forward to the thoughtful dialogue here. Here we are seated at a congressional table used for hearings, and the seats are always low, so you feel like you're sitting at the kiddie table at the big dinner. But in any case, I'll be trying to sit upright the whole time, so that's a good thing, I guess. I dissented, as you may know, to the FCC's December 2010 net neutrality order, and wrote a rather notoriously long dissent. And there's a good solid section there on First Amendment law and why actually the order does violate the First Amendment. As Jackie was pointing out, and subsequently Craig as well, that the First Amendment is about erecting a bulwark against state action into a number of things, be it free speech or religious liberty or the right to police assemble and petition your government and all those various parts of it. So I think that it's actually it's faulty. The notion that you have private capital building telecom networks, communications networks, information systems networks, and these are private networks. They've not been regulated the way we regulated the mall bell monopoly, so they are not common carriage, and that is sustained Supreme Court review, that notion. So when you're talking about private speakers, it's delicate and it can be difficult, but the government should not be refereeing shouting matches between private speakers. The Supreme Court has said as much. The word censorship can mean a number of things, but as a term of art in First Amendment constitutional law, censorship must involve state action. And there's a 1983 Supreme Court case on that, the Scott case, that talks about this. So private parties can try to shout each other down, but in the case of the net neutrality order, I felt it was a violation of the First Amendment precisely because here was state involvement regulating speech.
Great. Let's take a step back and talk a little bit about First Amendment doctrine. Kelly Shackelford is an expert on this area. Kelly, can you tell us, sort of generally speaking, what prerequisites must be satisfied before the First Amendment can be used to restrict a private organization or an organization from trampling on the rights of others?
Yeah, one of the things that sometimes people forget is the Constitution only constrains the government. It doesn't constrain private citizens. It protects private citizens. And so generally there's a requirement of state action. There has to be government activity. There are exceptions through the years, and those exceptions would be things like if there was an association, for instance, and that association had private entities and government entities, then that association could be subject to the First Amendment and the Constitution. If a private entity and the government are joint conspirators in the violation of someone's civil rights, which goes back to some of the restaurants and some of the places that were actually working with the government to deny people on the basis of their race service, that private entity could actually be sued along with the government because there was a joint conspiracy that was going on. And then outside of that, I would say this is not a U.S. type Supreme Court, but there has been, for instance, a state Supreme Court decision that actually used the approach that, for instance, a shopping mall, has all of the qualities of being like a public street or a marketplace, and therefore they actually applied their state constitution to that situation. And so you can originally very quickly see how arguments could be made to try to actually bring a number of the things we're talking about under some sort of government intervention. And I would say one of the summaries of what we're talking about today, if like Apple and Google and everybody was listening, is you really need to get your act in order, because if you don't, I'm afraid what is going to happen is the government is going to find a way to get involved in this, and I think that will be bad for all of us. And so the best solution is for these companies to actually come up with self-policing that respects the principles of this country and that doesn't engage in this sort of religious censorship that we're starting to see.
So the general rule is that the free speech clause or the First Amendment only restrains private companies, and these exceptions that you listed are pretty rare. I don't know about you, but my experience as a First Amendment litigator, it's extremely rare that you'd be able to establish that a private entity is a state actor and thus subject to that. But, I think your points about the voluntary efforts, and we're going to talk about that more later on, are well taken. Let's take the doctrines, the constitutional doctrines that you mentioned, and maybe ask Craig about applying them down to the subject of our panel today, which these new media companies. Is there a particular state of law with respect to the applicability of the First Amendment to restrain the power of these private companies to censor speech or restrict speech?
Greg, there have only been a handful of cases that have really faced this issue front and center. One was I think it was a 2003 case involving AOL. A private citizen complaining about AOL's failing to enforce its policy from a free speech standpoint. And the court, it was the Third Circuit Court of Appeals, was very clear. They said, look, this is a private company. The First Amendment, as Kelly has pointed out, and we all seem to agree, doesn't apply to actions of private companies. They went no further than that, by the way. In our white paper report, we did suggest a couple of theories. And one of the things that lawyers do is they cook up theories, and then judges eventually shoot a lot of them down. But one of the theories that I've often thought about, not that I'm advancing it or that I think that this theory should be put to any good use, but as broadcasters use frequency, the airwaves, which is deemed to be a public resource, as telephone companies use electricity and the means of communication therein, which is deemed to be a public resource, subjecting them all to be treated as public utilities. What is the nature of the Internet? Is the Internet a public resource like electricity or like broadcast frequency? If it is, then does a company's dipping its toe or foot or more than that into the Internet to create these billion-dollar industries — now Facebook is worth apparently about $83 billion — does that convert them to a utility or something that can be governed or regulated as a utility? Again, I'm not suggesting, nor is our organization, NRB, suggesting that they should be treated as a utility, they should be regulated. Again, I think a lot of us, in fact probably all of us in this panel, believe that would be bad for policy, bad for freedom, and certainly bad for private enterprise. The problem is that a solution needs to be done. It needs to be done in the private sector. Now, that 2003 case was followed again in 2007 involving Google. Somebody wanted to place an ad on their search engine. They refused to place it for content reasons. Court again reiterated the Third Circuit standard. Now, going back to what we've also said, though, that there is no free speech right of an individual to protest, most likely, censorship by a new media platform. There is the right of a platform like Google or Facebook or Yahoo to complain about government encroachment on their editorial decision about what content they post. And I would point out the Yahoo case where the nation of France, through the European Union, got a court order prohibiting Yahoo from posting anything that would advance the sentiments or beliefs of Nazism, also prohibiting Holocaust deniers from being able to post on their site as well. Now, that was a European order. The federal court over here in the United States held on the grounds of the First Amendment, Yahoo had the right not to be constrained by those sort of viewpoint content acts of censorship. So clearly these platforms have First Amendment protection. The question is, what do we do about the downstream First Amendment or free speech values? I don't say rights. I say values or interests of the citizens that use those platforms.
I'm glad that you invoked the international example. I wanted to ask Commissioner McDowell a question that relates to that. A couple of years ago in 2010, when the FCC proposed adoption of regulations about the open internet, you dissented, as you mentioned earlier. But among your concerns was the message that government regulation of the internet in America might send to the international community. You noted that the technical management of the internet historically has been in the hands of nonprofit technology groups, not in the hands of the government. Two questions about that. Do you see any movement afoot for international control of the internet? And second, do you see that as a better or worse solution or a treatment than leaving control of the web in the hands of the private new media technology companies?
So normally it's very difficult for me to speak in a short period of time on this topic, so just poke me in the ribs if I speak too long. But to answer your question, yes, unfortunately, there's a very well-organized international effort for the International Telecommunication Union, which is essentially a subsidiary of the UN, to exercise regulatory control over internet governance in particular. This is something that's gone on actually for many years, and over the years the United States, through our State Department, or the UK or some other countries have been able to invoke parliamentary maneuvers to get these ideas tabled or to set up other entities such as the Internet Governance Forum where foreign governments can air their views. But we do see a renewed push in the past couple of years from China and Russia in particular to have UN control of the Internet through the ITU. And don't take my word for it. I wrote an op-ed in the Wall Street Journal back in February quoting Vladimir Putin, and that was pretty much verbatim what he said was his objective, is to have international control of the Internet through the ITU. So if you look at the countries pushing for this, China, Russia, Iran, Saudi Arabia, these aren't known as open societies with great freedoms of speech. But if you do look around the globe, you'll see roughly 196 countries, depending on who we're recognizing today or not, and about 173 of them guarantee the right to free speech. Then following those rights of free speech is a bunch of fine print. And there seems to be a law of jurisdictional or jurisprudential physics where the more fine print there is after an enumerated right, the less effective or strong the right is. So if you look at what China has said, I'm going to read here something about China's view of free speech on the internet, and it has a white paper that came out a couple of years ago called Invoking Free Speech on the Internet. China, if you didn't know, is very much in favor of free speech on the internet, apparently. But the fine print afterwards says, no organization, is a quote, or individual may produce, duplicate, announce, or disseminate information on the internet that could have the effect of subverting state power, damaging state honor and interests, jeopardizing state religious policy, spreading rumors, or anything that is forbidden by laws and administrative regulations, just as a catch-all in case they forgot anything. So they're very much in favor, of course, of free speech on the internet. And these are the people who are trying to get the ITU to have this multinational intergovernmental regulation of the internet. So it's really my #1 priority. Thank you for giving me the opportunity to talk about it. And this is the short version, believe it or not. But it's very real. I'm working closely with the Obama State Department, which substantively seems to be right on board in opposition to this effort. And I'm hopeful that that will be the case through this December when there's a big treaty negotiation in Dubai. But our efforts shouldn't end there. these people are patient and they're incremental and they're very determined. So we need to be looking at this for years and years to come.
Thank you. Let me turn to Ryan Anderson from Heritage. Ryan, what are the policy reasons, either for or against, invoking and applying the principles and values of the First Amendment, not necessarily the law, but the principles and values of the First Amendment to the actions of private new media companies?
Sure. I think one thing we should realize is that to a certain extent the values of the First Amendment are actually being embodied and embraced and invoked and put in practice by the new media companies themselves. So the way that we phrase the discussion is that it's between free speech interests of citizens and then free enterprise rights of the companies. But the companies themselves also have free speech interests and free speech rights at stake. And so my right to free speech doesn't require anyone with the duty to provide me either with a speech or with a podium. And so in the same way, if you own the podium and if you own the speech, you might want to have some control over the content of it. And my concern here from a policy perspective is that given the current political climate, if we empower the government, I mean, the first word in the First Amendment is Congress shall make no law, respecting establishment of religion, but also abridging freedom of speech and the press and of association. And so my concern would be more of what happens to the evangelical who runs a printing press or a T-shirt press. I think ADF now has a case where there's an evangelical Christian who runs a printing company. He prints T-shirts. Someone came in wanting to print a bunch of gay pride T-shirts. And he said, look, I'm not interested in that. Like, that's not what I do. I view my business as part of my ministry, as part of my life as a Christian. And so I don't want to print messages that I think are antithetical to that. I think he even referred the guy to another printing press that would do it. And now he's being sued, and I think you guys are litigating the case. I don't want the state to come in and tell him that he has to print that T-shirt. In the same way that I don't want the state to tell pro-life pharmacists that they have to fill prescriptions for the morning after pill or for abortion pills or things like that. And I think the reason why is that the printing press owner, the pharmacist, they also have First Amendment rights. So I would want to say that Apple, Microsoft, various internet service providers, they also have interest in the type of company they're going to be. And I think most of us were probably supportive of when Steve Jobs said they weren't going to have an app for pornography. We thought that was a responsible use of, you could call it censorship, you could call it some form of stewardship, something like that, that the purpose of a media like the internet is to actually ennoble and elevate the mind to greater things, and that pornography debases it, and he was making a value judgment. And so look, sometimes we're going to agree with the value judgment, sometimes we're going to disagree. Part of living in a free society is actually having competition. So if we don't like the censorship that Apple's doing on its iTunes market, it creates a market for a pro-life or a pro-marriage or a pro-Christian media platform. I think the biggest failure here is that Christians haven't risen to prominence in positions of business to be making these value judgments. And that's, the blame shouldn't be placed on those who have, but it should be placed on ourselves for not controlling these companies.
Well, I sense agreement on the panel that the free speech clause of the First Amendment is not something that those that have been censored by the new media companies or restricted or regulated by the new media companies can use. You can't run into court and sue Apple and be successful. That seems to be the consensus among you, nor would that probably be a good idea is what I'm hearing. But what about the new media companies using the First Amendment as sort of a paradigm, a voluntary paradigm? Not necessarily legally required to follow the doctrines of the First Amendment, but just a commitment to follow the principles behind it. In a sense, act as if they were the government, even if they're legally, in a legal sense, free to ignore what the First Amendment says. Let me ask Kelly a question about that topic. Is there any disadvantage to urging the use of the First Amendment doctrines, First Amendment principles, which is, of course, designed to restrain government, as the best model for private enterprise to follow? Any disadvantage to that?
Well, obviously, we're talking about self-regulation now. We're not talking about government. I think there's a lot of wisdom to using the principles because if you look at a lot of these issues, we've really struggled through them in our courts with different scenarios, with how, where do we draw the line, where do we really allow for freedom, and I think that learn from that. You can learn from other struggles of judges and intellectuals and others who are trying to figure out how do we stop incitement to violence, but allow things that we find that we disagree with, that we find repugnant. So I think there's some wisdom in it. I would say with a caveat, though, that kind of goes back to a little bit what Ryan was saying, and that is that paradigm is meant for the government. Therefore, it would apply to large, almost monopolistic companies. I think that it would be a mistake to say that that would be wise for everybody. I think the best policing mechanism, if we could make it happen, which we can't, but in the best world, we would have true diversity amongst companies. And they would police one another. Because no one would want to do a bad approach because they would lose market share to everyone else. And so that would be really the ultimate answer, is if we had not some sort of one-size-fits-all because of they've agreed to it or whatever, but because just competition would, and we've got diversity, and you couldn't afford to do that because so-and-so would do it differently. But I do think it would be really wise. I think of a lot of the things that have been struggled through in the courts, and as I'm reading through some of the law review articles that are out there, as I'm reading through what Craig and NRB wrote in the paper, there are a lot of ideas being thrown out, some of which I think are very unwise because of what I've seen through my 23 years of doing First Amendment law, and how the courts work through those and what they learned. And I don't think we should have to learn the same lessons over again with regard to freedom, free speech.
Your point about the size of the entity sort of struck me because, ADF, like a lot of nonprofit organizations, has a Facebook presence and will make a post and then invite people to comment. Well, we have a user policy, and occasionally people have gone too far in the kind of language that they've used, and frankly, it's a somewhat subjective judgment when we decide how far someone has gone, and we feel we're exercising our First Amendment rights when we say, look, sorry, you've crossed the line 3 times and you can no longer comment anymore. I view that as an exercise of our freedom, but we're not in the same position as possessing a near monopoly as, say, Facebook or Google. So I think your distinction between large and small makes sense from the perspective of First Amendment values. Does that sound about right?
No, you're exactly right. And where, again, I'm not so smart to figure this stuff out. It's just like there's almost pockets of law that hit all the areas we're talking about where the courts have struggled through it, and those who operate in those areas recognize it. So, for instance, this concept of allowing different groups to provide different choices and that being the best for freedom for everybody is really one that I've seen most recently in the area of church autonomy. And that's the idea that maybe you don't like that this church is kicking this person out because they got pregnant before they were married. And you say, well, that's not the kind of church, or that's not the kind of church school I like. But the point is to allow one to have that position, one to have a different position, one to have a totally different position. Now you've got all these choices where people can actually choose, and the whole paradigm is religious freedom. Yeah. And if the government were to come and say, this is the best approach for everyone, you really rob everyone of those choices. So I think for the smaller groups, it really is important that they have freedom. But I think as you get larger, if they don't exercise these types of principles, it's going to be very problematic, and the whole system is going to lose out.
Yeah. You raised a good point about competition being a good solution. At the same time, I think all of us would acknowledge that Facebook is probably going to be dominant in what it does for the time being. Apple's going to probably continue to be dominant with its App Store and all of that. So in the meantime, if we're moving towards a sort of voluntary compliance approach where we're encouraging these new media companies to try to act in a manner that's consistent with the principles and values of the First Amendment, how would we go about doing that, Craig? How would we start? Would it be some kind of Internet Bill of Rights, or what are your thoughts about how that might work?
I've been thinking about this in terms of a Bill of Rights for the Internet that we would ask new media platforms to voluntarily assume. And I thought back to my college days. I was an editor of a student newspaper back then, and that was when the Progressive magazine wanted to publish an article about how to make a nuclear weapon. And federal court jumped in, DOJ filed criminal charges and restraining orders, and then it was learned that the article, the content of the article about making a nuclear bomb could be found in reference libraries and information that was already publicized. I was invited to some panels with editors, and I was in pretty tall cotton at the time, just being a student editor during those discussions. But one thing I remember the editors of the Milwaukee Journal, the Chicago Tribune, and others saying is that if we don't police ourselves, we know who will. And so newspapers have had codes of ethics, and they've had standards of journalism, and they've had banner headlines, all the news that's fit to print, not that which is unfit to print. Now, we could debate whether or not that standard has been kept properly or not, but the fact is they have these voluntary assumptions of ethical and professional responsibility. So the question is, where are our standards of responsibility for free speech among these platforms which have made billions of dollars on communication provided not by them, but by us? The public provides the content. I'd like to make a bit of an analogy, and I love folks to poke holes in it, because this is frontier policy and frontier law. The analogy that I use is this. I think that the First Amendment jurisprudence of the Supreme Court is the best possible paradigm to urge for the creation of a voluntary Bill of Rights that should be assumed by these new media companies. Reason is, number one, it's easily retrievable. In other words, you can identify it as a body of law. You can argue about what the Supreme Court opinions mean, but most of us would probably agree. In fact, Kelly and Greg and I have all litigated First Amendment cases over the course of our careers, and we know that there are nuances and differences of opinion, but by and large there's a general consensus as to what most of these opinions mean, and we could tick off the exceptions to free speech. The best approach is narrow, well-defined exceptions. I'll use FCC as an example. NRB filed an amicus brief with the United States Supreme Court affirming the FCC's indecency guidelines. We felt that they were not perfect, but well articulated, equally applied, rationally applied, reasonably applied, and we also felt that they fit within a paradigm, a history of protection of children from certain content that you wouldn't necessarily have to protect adults from. So indecency that you protect from children, or in venues where children have special access, might not be able to be protected from adult eyes, or should be protected. So indecency, child pornography, obscenity, areas of indecency where children can have special access would be an area that I would feel historically the Supreme Court has affirmed the right to exclude that or control it. I think the new media ought to respect that. And by the way, they seem to be doing a good job. Apple, Google, Facebook, all of them have basically said we don't want salacious